This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, 1300. Did you know live Senate video is now available at youtube.com/@Senate of Virginia. Senate Committee Room, 1300. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, 1300. Did you know live Senate video is now available at youtube.com/@Senate of Virginia. Senate Committee Room, 1300. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, 1300. Did you know live Senate video is now available at youtube.com/@Senate of Virginia.
Finance and Appropriations Committee. I have a sign-up list. I did want to say, though, we're going to take the claims bill at the end of the agenda for those who have claims bills. But I wanted to start with Delegate Vivian Watts. He's got one.
Is House Bill 1715 on mail theft. It is, the House substitute is identical to the Senate substitute, and again, it allows state enforcement of mail theft, which includes packages as well as letters.
Okay, and that passed the Senate unanimously, and it's identical. Is there a motion to report?
Second.
Okay. All in favor, please signify by saying aye.
Aye.
Aye. Any opposed? Thank you, Delegate Watts. Thanks
Thank
for being
you,
here
Mr.
so early.
Chairman. Member of the committee.
Okay. Then we had Delegate Keys-Gamarra.
Good morning, Mr. Chair, members of the committee. I am here regarding the solitary confinement bill. Essentially, in a nutshell, is to reduce the use of that and to try to make sure that people get the activity that they need. This is identical to Senator Bagby's bill.
Okay, so with that said, that bill has, we already passed that bill. Is there a motion?
Move the report be reported.
And there's a motion and a second, so all in favor say aye.
Aye.
Any opposed? No. Okay, and we'll note 2 noes. Thank you.
Thank you.
Thank you. Okay, next we've got, Delegate Sullivan, your bills are just claims bills? Not just claims bills, but you have claims bills, right? That's correct. Okay, we're going to come back to you. Delegate Walker?
Morning, Mr. Chairman.
Good morning.
All right, ready to go?
This is House Bill 1998.
Yes, sir. Correct, Mr. Chairman.
Okay. This, I guess, is a new bill to us, but why don't you, if you could, just explain it?
Yes, sir. It was referred to finance. Correct.
Right, but if you, I don't think members of this committee are all on court, so if you could just tell us the subject of the bill briefly, what it does.
Okay, so apparently there's some financial, when it comes to, we're changing the classification from the sexual extortion here from a misdemeanor up to a felony 5, so that would be some imprisonment maybe at some point down the line there. It just helps the courts deal with these bad actors out here that have housing, they're taking advantage of women, so that's the bill before us.
Thank you. Folks understand the bill? It came out of, yes.
I do, and this is a growing problem.
Senator Martin.
This is a growing problem. It is a situation where people are more and more using material that they have gotten on the internet, pictures they've taken and what have you, and using it for extortive purposes.
I think this covers a different circumstance. Do you
This
wanna
is dealing
briefly
with
explain it?
housing, excuse me,
Housing,
Senator.
but
Yeah.
they are doing that. It's just becoming a growing problem of people taking advantage of their positions of power, their possession of photographs and what have you. And I think sending a felony message, which could be reduced to a misdemeanor if the prosecutor feels that the details were not as egregious, but I think this is a good move.
Okay, there's a motion and a second to report the bill. All in favor, please signify by saying aye.
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 Any opposed? Okay, the bill recommends reporting to full committee. Thank you.
Thank you very much.
Okay, next we've got Delegate Scott, Philip Scott. Welcome.
Good morning, Mr. Chairman, members of the subcommittee. Before you is House Bill 2406. This is identical to Senator Reeves' bill, Senate Bill 861, that changes the language in code from police officer to law enforcement officer as defined in 18.2-57. It's a cleanup bill and hope the committee acts favorably.
Thank you. This was the unanimous recommendation of the Courts of Justice Committee.
Recommend the bill be reported.
Okay, all in favor, please signify by saying aye.
Aye.
Any opposed? Okay, thank you.
Thank you. You all have a great morning.
Okay, we have Delegate Hernandez next. We're going to take him when he comes in. And then we've got Delegate Cousins. Let's see. Welcome.
Good morning, thank you. And good morning, members of the subcommittee.
Okay, why don't you tell us about the bill?
Okay, sure. So HB 2221 would require the DOC to collaborate with the DMV and other relevant state agencies to ensure that someone who is leaving incarceration has a photo issued government issued ID before their discharge into the community. And I do have just a few stats. We know that today many Virginians leave DOC. I do have a substitute, sorry about that. Yes, thank you.
Okay, there's a motion and second to adopt the amendments. All in favor, say aye.
Aye.
Any opposed? Okay, the bill as amended is before us.
Thank you. And just to provide a snapshot, DOC data shows that over the month of September last year, 410 inmates were released from Virginia's prisons, and only 178 of them, so less than half, were released with a state ID. 17 states across the country require their respective departments of correction to provide incarcerated individuals with an ID before their release. And so these programs have broad bipartisan support, so.
Second.
There's a motion and a second to report the bill, which would.
As amended.
As amended. All in favor, please signify by saying aye.
Aye.
Any opposed? Okay, the bill reports. Thank you.
Thank you.
Okay, next on the list, I have Delegate Henson.
Good early morning.
Good morning.
Good morning.
Mr. Chairman, members of the committee, House Bill 2555 is modeled after a bill that passed the General Assembly last year by Senator Williams Graves. This bill creates a process for people convicted of marijuana-related offenses who were committed before July 1st, 2021, who also remains incarcerated or on probation to be considered for sentence modification.
This bill was recommended by the Courts Committee on a 9-6
I move
vote.
the bill be reported.
Okay. There's a motion and a second to report. All in favor, please signify by saying aye.
Aye.
2 noes. Okay, and there are two noes will be noted. Okay. Next on the, that was your only bill, right?
Yep.
Okay.
Have a good day.
Thank you.
Thank you. Delegate Delaney.
Good morning, Mr. Chair. Good morning, committee. I have two bills before you today.
Okay, do you want to start with a particular one?
We can do 1968 victims, that's my victims compensation bill. You had a similar bill, Senate Bill 1200, I believe, by Senator Deeds. This expands access to the fund for victims who have been historically excluded by extending the timeline for eligibility from 1 year to 3 years after a crime occurs or after a death resulting from a crime. It would also extend the timeline up to 3 years in cases where someone is filing a claim on behalf of a minor or incapacitated person.
Okay.
Oh, you have, okay.
Okay, so we'll consider the line amendment. All in favor, please say aye.
Aye.
Any opposed? Okay, the bill is amended. It's before us. Please continue.
So as described, it expands access to the Victims' Compensation Fund by extending the timeline for those requests.
Okay, and this is now, I guess, identical to SB 1200 from Senator Deeds, which we passed a unanimous vote, except that, now it's identical.
Yes.
Okay, so there's a motion and a second to report. All in favor, please say aye.
Aye.
Any opposed? Okay, that bill recommends reporting
Thank you, Mr.
to
Chair.
the full
Thank you,
committee as amended.
I also have House Bill 1728.
Yes.
And this bill creates a more trauma-informed courtroom by expanding access to remote testimony for child victims who now, under this bill, would meet a standard of moderate emotional trauma. It reduces the trauma from severe to moderate to ensure that, children have better access to a trauma-informed courtroom. Still allows for cross-examination.
Okay. Yes, Senator McDougal.
Mr. Chairman, I think it also expands what type of technology you can use to do the two-way communication, because not every courtroom has a CCTV device. Mr. Chairman, I started back when I was prosecuting, which has been eons ago, 20-some years. This was brand new, but now it is definitely something that impacts children. And I believe the way the language is that it's not just trauma or fear of being in the courtroom, but it's of the defendant. So it really, I think, is focused on something that it's important. So I'd move to report.
Second. Okay. HB 1728. All in favor, please say aye.
Aye.
Any opposed? Okay, that bill is recommended for reporting.
Thank you, Mr.
Thank
Chair.
you.
Thank you, committee.
Okay, next we have Delegate Thomas.
Yes, Mr. Chairman.
Thank you. What's our bill number here?
2657.
Okay, why don't you tell us about it?
Yes, Mr. Chairman, thank you. Good morning, members of the committee. This was originally a fentanyl manslaughter bill, but it was amended in Senate courts to conform to Senator McDougal's Senate Bill 746, which would make it felony murder for dealing fentanyl that results in the death of another. Senator McDougal's bill has passed out of House courts and is now on the House floor. This bill passed out of Senate courts after being amended unanimously. Essentially, the differences between the two postures is the type of punishment, whether that's manslaughter or felony murder, and then also the class of victim, which is either going to be just minors or all potential victims, but happy to answer any questions.
Thank you. I think Senator McDougal has a question or a comment.
Mr. Chairman, I'm going to move to report at the appropriate time, but I must say Delegate Thomas's version is better than the Senate version that we have now. The Senate version says if your 17-year-old child dies, the person who participated in their murder can be prosecuted. But if your 18-year-old child dies, they cannot. I cannot understand that. I do not think it matters how old your child it is. And the House version also doesn't say the sole proximate cause, because most of the time when people are taking something laced with fentanyl, it has heroin, it has oxycodone, it has marijuana, there's some other drug there, which makes it almost a legal impossibility to determine that it is the sole cause of the death. So I like Senator Delegate Thomas's version better, and I hope that we do one better thing in the Senate, and that is exclude all the other potential charges, like the fentanyl is a terrorism device, and so we exclude that from being prosecuted if this section is prosecuted, which I think is a good point. But I hope we'll get to where Delegate Thomas's is in a very short term.
Okay, your concerns are noted, but there's a motion to report and a second.
Yes, second.
Okay, all in favor, please signify by saying aye.
Aye.
Any opposed?
Aye.
Okay, so that one dissension is noted. Thank you. Is that your only bill today?
That's my only bill. Thank you, Mr. Chairman,
Okay,
members of the
thank you. Next, I've got Delegate Simons.
Thank you, Mr. Chair. May I go ahead?
Please.
HB 2033 directs the Virginia Alcoholic Beverage Control Authority to add a training course to their website to help bartenders and convenience store workers learn how to recognize and report instances of suspected human trafficking. This online course is already offered to hotel employees, casino workers, and last year private security guards through the Department of Criminal Justice Services website. But this bill directs DCJS to develop the course so that ABC can put it on their website.
And I believe we've also heard others for past legislation requiring similar awareness curriculum for proprietors of short-term rentals. So this tracks with that and the others that you mentioned. Is there a motion or a comment? Move to report. And
Second.
Second. All in favor, please signify by saying aye.
Aye.
Any opposed? Okay, that bill reports. Thank you.
Thank you.
Next, we've got Delegate Jones.
Thank you, Mr. Chair, members of committee. Good morning. I have three bills. If I could start with 1660. Senator Devon?
Yes, please go ahead.
Senator, it is HB 1660, excuse me, is a bill on auto sears. It has conformed with Senator Perry's SB 886, which simply seeks to tighten up and ensure consistency between the definitions of an auto sear or a trigger activator.
Thank you. I think Senator McDougal either had a question or a comment.
Mr. Chairman, I'm under no illusion how the vote's going to go, but I do believe there's a difference between an auto sear and a trigger activator. Last year we did pass, and I supported the elimination or to make it illegal to possess an auto sear, but I think that this is going to catch some other people that we don't intend to catch. So I know there'll be a motion, but
Okay.
I do think there's a difference between the two.
Thank you.
Two.
Thank you. Senator, HB 1661, Universal Standard of Minimum Payment. 1661 updates Virginia law to offer a flexible payment option for fines, including deferred, modified, or installment plans, and exempt. Yes, I am. Yes, sir.
So, all in favor of the substitute, please signify by saying aye.
I'd like council to tell us what the substitute, how it changes a bit.
About the qualifications for the payment.
Madam Chair, or Mr. Chair, the substitute provides that if the defendant requests to enter into an installment agreement, the court may offer installment payments of $25 per month or a higher amount depending on a defendant's ability to pay, or less than $25 per month if the defendant is determined to be indigent. I believe the bill as it came to us left the discretion to the defendant himself, not the court.
With the payment plans, anything else to note before we vote?
No,
Okay.
sir.
So is there a motion to report
I
as
move the bill be
the
reported.
substitute? Okay. And if there's,
As the substitute.
and Senator Hashmi seconds. All in favor, please signify by saying aye.
Aye.
Any opposed?
We're going to abstain.
Okay, so two abstentions. And, yeah, I think this may take care of your concerns.
Yeah.
Mr. Chair, can I ask Mr. Kimmerman?
One question, I know we
Sure.
voted, but just when you, as I'm looking at lines 41, are you reading this to if the court determines the person is indigent, which if they received a public defender or court appointed, that determination has already been made, that the court has to at that point do less than 25, or that they have the authority to do less than 25?
Mr. Chair, Senator McDougal, it's discretionary, so it's the court may offer that less than $25 per month if the defendant's determined to be indigent.
Thank you, Mr. Chairman.
Now we've got House Bill 1665.
Yes, sir. Mr. Chair, this is a bill that was passed last year but vetoed by the governor just for adding a $10 charge to pull someone's records of what they actually owe. What 1665 simply seeks to do is provide an itemized statement of financial obligations.
Okay. So basically, upon, if the defendant would be made aware of all their obligations upon their,
That they would be able to request what they
Yes.
owe per different locality. Currently, right now, they just get one lump sum, and they don't know whether it goes to restitution or whether it's for this particular fine. And this would just provide an itemized account.
okay, thank you. Is there a motion?
Move the bill be reported.
Okay, motion and second from Senator Marston to report. All in favor, please signify by saying aye.
Aye.
And we'll note 2 noes. Okay, thank you.
Thank you, Mr. Chair. That was it for me.
Okay. Next up, I've got Doug Bagans. Oh, and then we'll take Doug Hernandez. Okay.
Good morning, Mr. Chair, members of the subcommittee. First, I believe I have a substitute to move.
Okay, which bill is this?
Excuse me, HB 1597.
Okay, so we have a substitute for 1597, no?
Was it adopted already,
Maybe
Council?
was it adopted in the other committee?
Okay.
Let me pull it up here.
When I was looking on LS, I didn't see it. I just wanted to make sure it was before. Okay.
Oh, I did have a question about a potential amendment. This is the bill about secure storage for firearms and is very similar to, well, they're identical to Senator Boysko, the provisions in there, but it requires a public awareness campaign, and I was just going to ask if we could say that with such funds as available for the state police awareness campaign.
I will accept that.
Okay,
Chair.
so that's, is there?
Move that.
And I second that. Mr. Chairman, that's, this also covers the bill that we passed out of here on secure storage in cars. So
Okay.
this is a real comprehensive bill. It's a good one.
Thank you. Okay, first we're going to vote on the amendment. All in favor, say aye.
Aye.
Any opposed? Okay. Now, I think people know what the bill's about, the safe storage bill. All in favor, well, is there a motion?
Recommend be reported as
Second.
amended.
Okay. A motion and second to report as amended. All in favor, say aye.
Aye.
Any opposed? 2 noes. Okay, we'll note 2 noes. Okay. Next, I saw Delegate Hernandez came back, so why don't you come forward? Thank you.
Thank you, Mr. Chair, members of the committee. This is HB 1977. This will look familiar. I believe it's an identical cognate from Senator Williams-Graves, SB 1110. This is a bill to protect our frontline healthcare workers by keeping firearms and other dangerous weapons out of hospital. I'll just share in 2 local hospitals in 757 and Centera, they've had to intercept almost 4,000 of these dangerous weapons over the last few years. So this bill is narrowly tailored, it has some important exemptions, and hope it will be the will of the committee to support the bill.
Okay, thank you for bringing this. This is identical to what we passed for Senator Williams-Graves.
Recommend the bill be reported.
Second.
Okay, there's a motion and a second to report HB 1977. All in favor, say aye.
Aye.
Aye. And, okay, and I'm noting 2 noes. Okay. And to give another, or is that?
That's all for me.
Okay.
Easy
Thank
today.
you, Delegate.
Thank you so much.
Okay. Then, I believe, is Delegate Price next? Welcome.
I have 2 before you, and House Bill 1726 is identical to Senator Locke's bill, Senate Bill 757 that passed unanimously, with the protecting the shipyards and other like buildings from drone usage.
Okay. So we
Or
passed this. Senator
erroneous.
McDougal?
Mr. Chairman, I think this is a great bill, and if you recall, we had the discussion when Senator Locke was here about a Chinese national that flew the drone over the shipyard and then was actually stopped leaving the country in California. Mr. Chairman, I just wanted to speak not about this issue. It came to my attention that some other areas that were highly sensitive also had drone excursions in the last 2 weeks. And as we go through this, I do think we need to have a conversation about what our law enforcement and or National Guard can do in those situations, because right now, they don't actually have the ability under our statute to deploy drones that catch them, or deploy abilities to take those drones that are spying over some secure facilities out. So we probably need to find a way to do it. I don't know that this is the vehicle, but it is an important issue, and I'm really glad we have this going forward.
Mr. Chair, if I could just say
Please.
one quick thing. So we passed the bill out of the House with the enactment clause that directed the Crime Commission to look at other such issues surrounding it. Found out in courts that we do not legislate what the Crime Commission does, but a letter will be going to the Crime Commission, and so we can get the chair of courts to add that part into the letter, I'm sure.
Thank you. Yeah, I think that's a good idea. There's a motion and a second to report HB 1726. All in favor, say aye. Aye. Any opposed? Okay. That bill reports.
I also have, thank you. I also have House Bill 1736, and I think there may be a substitute.
Okay. Is there a motion to adopt the
Substitute we
substitute?
agreed to.
Okay. There's a motion and a second that we adopt the substitute for 1736. All in favor, please signify by saying aye.
Aye.
Okay. So substitutes before us.
Could we get counsel to just?
Yeah, that's what I was going to ask. This is the Virginia Center for Firearm Violence Intervention and Prevention. Can counsel explain, I believe the substitute added a delayed enactment, is that correct? Is there more?
Mr. Chair, the substitute would add a delayed effective date of July 1, 2026. It would also remove the fund portion of the bill, so it would just create the Virginia Center for Firearm Violence Intervention and Prevention.
Okay, and there's nothing to prevent us from funding that in the future, or adding, right? Yes. Okay, so that'll be discussed there.
Mr. Chairman?
Yes.
Just as a matter of curiosity, staff, are all the federal rules against doing any kind of firearm research are still in place, are they not?
Mr. Chair?
So
For about 2 decades, the CDC was actually prohibited from doing research on it. Under the previous administration, they were allowed. We anticipate that prohibition will come back. But not only that, the White House Office of Gun Violence Prevention has been disbanded.
Okay, thank you.
Okay. So Senator.
Mr. Chairman, if maybe Mr. Kitterman can correct me if I'm wrong, but this bill does two things. One, collects the information, which I think Senator Marsden was just discussing, but it also, is it duplicative of some of the duties of the Safer Communities legislation that we've passed historically?
Mr. Chair, Senator McDougal, I am not sure on that. I would have to double check. I might defer to Katie or
Mr. Chair,
Joanne.
if I could answer. It does, with the words that are listed, but not in how it is actually being practiced in real life. There are some gaps and some voids in what the Safer Communities Center is actually doing. This would allow for us to specifically look at the role of gun violence in communities like mine so that we can continue to be a resource to localities instead of having a piecemeal approach. There are, in Virginia, of the homicides, 39% of gun violence prevention, 39% are homicides, 59% are suicides. And so we want to make sure that that research is being done, but not only that, that our gun violence prevention strategies are actually informed by what's happening in Virginia.
Thank you for that explanation. Okay, the substitute is before us. Is there a motion to report?
Motion to report.
And a second?
And a
Okay.
second, yes.
Okay, so we'll now vote on reporting the substitute version of 1736. All in favor, say aye.
Aye.
Aye. Okay. 2 noes. Okay, those are noted. Thank you.
Thank you, committee.
Okay, now, I've got, Delegate Sebald, you have a claims bill, is that right? Okay, so I've got Delegate Simon has a non-claims bill, right? And then we'll move on to the claims bills after that.
Thank you, Mr. Chairman, members of the subcommittee. Good to see you this morning. House Bill 2783 expands Virginia's anti-swastika bill. We already have a bill that makes it a crime to place a swastika on property with the intent to intimidate. This bill says that, so it's currently illegal to place it on a school, a synagogue, another place. Oddly enough, it's not, though, illegal if you put it in my front yard. So this bill would expand the places where you couldn't do it. It also changes the definition to make clear that what we're talking about is the Nazi symbol, commonly known as a swastika. I know some of you may have heard from the Hindu community is very concerned that there's confusion about their holy symbol, and so this definitional change is meant to distinguish that so that we're not grabbing in too much as far as what a swastika is.
Thank you. And this bill is the unanimous recommendation of the Courts Committee. Unless there are further questions on this motion?
Mr. Chairman,
Senator McDougal.
I do. I continue to receive calls about this as late as 10:30 last night. And Mr. Chairman, I think we made it, we talked about this in Courts Committee. I think we made it better, but I still have some concerns because I think not only does the Hindu religion, but the Jain religion both use a symbol that is in Sanskrit referred to under the term swastika. I think we need to add a line in there between C and D that says Nazi, the swastika as used in this code section does not mean the symbol used by Hindu religion or Jain religion. I think there needs to be something specific
Let me
to.
ask counsel, does the bill not already say the Nazi symbol with intent to intimidate?
Mr. Chairman.
I want to ask counsel that.
Yes, Mr. Chair, it does.
Okay, Senator McDougal, you wanted to respond to that?
Yes, Mr. Chairman. Under that section D, it says, for purposes of this section, the symbol commonly known as a swastika, if it is used, that is prima facie evidence of intent to discriminate. So the issue is, if it's placed, you don't have to prove anything else. You just have to prove that the person put it there. And that's the real concern by adding private property of another without permission. Somebody who's Jain or Hindu has that symbol, they drive into somebody's parking lot, just the fact that they have it would put them in violation. So I think we did a positive thing by adding in the specific language Nazi symbol commonly known as, but I think we need to put something more specific saying that the Hindu symbol and the symbol used by Hindu and Jain religion is not this Nazi swastika definition.
And I believe the bill says without permission, but I want to come to Senator Hashmi. She's next in the queue.
Thank you, Mr. Chair, and I just wanted to align myself with the comments of Senator McDougal. I think it's really critical to clarify. The word swastika actually comes from an ancient Sanskrit word, and it is a very important symbol for many in the Indian community. And so I think having that clarification, separating the religious use of the swastika versus what we saw in Nazi Germany and in neo-Nazi literature is critical. I would like to see some clarification in the language.
Senator McDougal, do you have your suggested language for council as an amendment?
Mr. Chairman, this is a little bit off the cuff because it was late last night when I was going back and forth with some people like this, but I'd probably add a new section saying for purposes of this section, and I believe correct, it's the Hindu or Jain symbol commonly referred to as a swastika is not the Nazi symbol referred to in this
maybe in
the
concept.
statute.
Are you able to work that up?
Mr. Chair, I think we can add it to subsection D. So subsection D would say, for the purposes of this section, any such placing of a Nazi symbol commonly known as a swastika shall be prima facie evidence of an intent to intimidate another person or group of persons, period. Swastika does not include a swastika as used by the Hindu or
Jain.
Mr. Chairman.
Religions.
Mr. Chairman,
Senator Marsden.
a question for Senator McDougal. Would an affirmative defense be an appropriate thing here? I don't want to play lawyer, but that if its intent is to exercise your religious freedom, that would be an affirmative defense against any. Would that be simpler or?
Mr. Chairman, I think affirmative defenses in certain circumstances are appropriate. In this one, because we say, and Delegate Swastika is attorney too, Delegate Summers is attorney too, and he can, in that section D, when we're saying that use of a swastika is prima facie, that means that there's nothing else, you don't have to prove anything else.
Yeah,
and so that's why I think we need the clarification. And I think Delegate Simon recognized the problem and was very helpful working through this in committee.
Okay, so I'm going to ask Delegate Simon if he wants to comment.
Yeah, very quickly. I think I like the approach of adding it to D, right? And I think we tried to get there by explicitly using the Nazi symbol, or we can include the word only, but I also hear the community saying we want to see something in this statute that explicitly excludes our religious symbols, and we don't want to be roped into this. And so I like the idea of adding it in section D itself to say the Nazi symbols prima facie evidence, the Jain and Hindu symbols are not prima facie evidence. However we get to that wording, I agree with that intent and that concept, and I think that'd be a helpful addition to the bill.
Thank you, Delegate. Okay, so Senator McDougal moves and Senator Hashmi seconds that.
Mr. Chair.
Yes?
Just one quick addition. I did a quick Google search, and apparently the swastika is also a sacred symbol in the Buddhist religion. So I think I would encourage our staff attorneys to do a comprehensive search of all of the religious entities that should be identified if we're going to put this into the code.
Is that
Jainism, Buddhism,
Yes.
Hinduism, or Hindu. So there may be others, but that's the three that a quick Google search is revealing.
Yes. Did you have any other?
I'm happy to list out the specific religions. I hope nobody's going the direction where we say a religious symbol, because I wouldn't want somebody to say, well, my religion is this now. You know what I mean? I want to have to get into parsing that.
Okay. Okay. Thank you. Is council clear then? Okay. So did we have to vote on the amendment, adopting the amendment? All in favor say aye. Aye. Any opposed? Okay, so the bill as amended is before us. It was recommended from courts on a 15-0 vote.
Reported as amended.
Okay. There's a motion and second to recommend to the full committee the bill be reported. All in favor say aye. Aye. Any opposed? Okay, so that bill is recommended.
Thank you, Mr. Chairman. Thank you, members of the committee.
Thank you. Okay, now we have claims bills. Delegate Sullivan, I believe, was here first and has been waiting, and I think,
Mr. Chair, Delegate McClure is not in claims bill.
oh, I'm sorry, she's here. Okay, apologies. Delegate McClure, thank you.
I appreciate that, Mr. Chairman, members of the subcommittee. I have HB 1869, Mr. Chair.
Yes.
Thank you.
Yeah, so I believe this bill is nearly identical to what came from.
You want to move the substitute?
From Senator Perry, but the substitute is a little bit different.
That's correct, Mr. Chair.
So before we adopt it, I think what you were doing was just on lines 169 to 171, rather than stating the federal code section, you were taking words that were in the federal code section about the definition of intimate partner being someone within the previous 12 months was in a romantic dating or sexual relationship with a person that's determined by the length, nature, frequency, and type of interaction between the individuals involved in the relationship. And I believe you told me that Senator Perry was okay with this language?
Yes, Mr. Chair. So we removed the reference to the federal code, and then we took elements from the bipartisan federal definition and incorporated it. But the substitute also reverts the bill back to the original definition and then incorporates those elements into our original definition.
Okay. Are there any?
And that's agreed upon between me and the cognate's patron, Senator Perry.
Okay, so we're going to take up the substitute first. There was a motion and a second to adopt the substitute. All in favor of that, say aye.
Aye.
Aye. Any opposed? Okay. Now the bill's before us. I think people are familiar with this. Were there, before we vote, were there any further questions? Okay. So is there a motion to report this bill that would protect intimate partners, House Bill 1869?
Second.
Okay. So motion and second to recommend reporting of the substitute. All in favor, please signify by saying aye.
Aye.
Aye. Any opposed? Okay, well, no, 2 noes. Thank you.
Thank you, Mr. Chair, members of the
Looks like you made
subcommittee.
it through the weather.
Mr.
Okay.
Chairman,
Just
Delegate
saying, Ms.
Sullivan.
Delegate Williams is here.
Oh,
Does
I'm
not have
sorry.
claims bill.
Delegate Williams, yes, I didn't have you on my earlier list. Okay, yeah, come forward, please.
Thank you.
Which is your bill?
HB 2252. It's about probation, earned probation credits.
Okay, please explain it.
So this bill is about earned probation credits. It would incentivize probationers to do well on their probation. This matches the executive order that we saw from Governor Youngkin, and that data is being collected already by DOC. This would allow people to pass GED tests, things like that, to increase or decrease the amount of time they have to serve on probation. So that's the goal of the bill. As far as the fiscal impact, we know that this bill actually saves money when it comes to reducing recidivism and having less probation officers needing to fill the role for the ratio. This has been passed in several other states, and I can give you more information about those if you're interested.
I think you explained it. It allows the court to take into account things like education, employment, mental health programs, housing, and health insurance when they consider whether they want to decrease the probation period. It was recommended by the Courts Committee unanimously. And it's identical to SB 936 from Senator Craig that we passed unanimously. Is there a motion on this bill?
Be recorded.
Okay, is there a second? Second? Okay. Moved and seconded. All in favor of recommended reporting of HB 2252 to the full committee, please say aye.
Aye.
Aye. Any opposed? Thank you.
Thank you all.
Okay.
Mr. Chairman, Delegate Sullivan, I think we are going to take just a minute break to set up the remote testimony before we begin the claims
Understand.
bills, if
Thank
that's all right.
Okay. We're gonna be at ease for just a moment. We had a witness who's waited a long time to testify, and we are gonna make an exception and hear from them remotely in a moment.
Senate of Virginia, Richmond, Virginia.
kind
The
of set it up.
IT.
Okay, we're back.
We're back.
Okay, so we had a few other bills from patrons who weren't here, who I told Delegate Helmer that I would explain. His bill, 1797, on concealed handgun permits and reciprocity with other states. It amends the current requirement related to reciprocity that we would require that other states be adequate to prevent possession or permit of a permit or license by a person who be denied in the Commonwealth, except that the permit holder's age and type of weapon authorized. Maintains the requirement in current law that reciprocity applies to individuals 21 years and older. Are there questions before we consider this bill?
That identical to your bill?
I did not have this one, but we did pass nearly identical Delegate Helmer's bill last session that had an exemption. This bill now has an exemption for service members and their spouses.
Okay, so it's
Yeah.
similar to Senator Deeds.
I believe so. Yes. Is there a motion?
Move the bill be reported.
Okay, there's a motion and a second from Senator Hashmi. Oh, is this one? I'm sorry, this is 1797. I'm just going to look at my chart. We talked about adding a delayed enactment. That would be an amendment to thank you. Okay, so on line 56, to add an amendment that it wouldn't be effective till July 1st, 2026. Is there a motion, a second, to adopt that amendment?
Second.
Okay, so first we'll consider the amendment. All in favor, say aye.
Aye.
Any opposed? Okay, now we'll consider the
It'll
bill.
be changed to the effective date.
That's correct.
Okay, thank you.
So is there a motion to report the bill then as amended? Okay. All in favor, say aye.
Aye.
Any opposed? Okay.
2 noes.
Okay, we'll note the 2 noes. Okay, so that was, and then we had another bill from, was it Delegate Gardner, who I believe couldn't be here as well. She told me that yesterday. Was her bill?
1759.
Okay. Okay, this is House Bill 1759, and I'm just pulling up my notes.
Gardner.
Yeah, I don't.
Mr. Chairman, HB 1759 is identical to your bill, which passed the Senate unanimously.
Oh, yes.
It directs the Department of Workforce Development and Advancement and DOC to provide post-release job search assistance.
Okay, there's a motion, a second, to report HB 1759. All in favor, say aye.
Aye.
Aye. Okay, that bill's recommended for reporting.
1876 Colson.
Okay,
That
and
was
then,
the same as Deeds.
It is. I recommend.
which page of the chart is that on?
It's on
Number
your pa-
1.
It's on your
First
page.
page.
Oh, okay. The next one is identical to Senator Deeds' bill about allowing public institutions of higher education to adopt a policy about weapons, with some exceptions, identical to Senator Deeds' bill. Is there a motion to?
Recommend the bill be reported.
Okay, there's a motion and a second to recommend reporting. All in favor, say aye.
Aye.
Okay.
And then you have the Hayes HB 2631. Right at the
Okay.
top.
Okay, the next was for HB 2631 from Delegate Hayes, which was identical or nearly identical to SB 891 about a 5-day waiting period before a criminal, a 5-day waiting period after completing the criminal history record background check. Is there a motion?
Recommend bill be reported.
Okay, there's a motion and a second that we report HB 2631. All in favor, say aye.
Aye.
Aye. Any opposed? 2 noes. Okay. Okay.
1607.
Oh, yeah, okay, first,
Helmer.
from Delegate Helmer, HB 1607 deals with the purchase of assault weapons and ammunition feeding devices, which is similar to Senator Deeds, SB 1191. The bill is before us unless there are
Recommend the
questions.
bill be reported.
Okay, there's a motion and a second that we recommend HB 1607 for reporting. All in favor, please say aye.
Aye.
Okay, we note the 2 noes, which will be noted on the next one as well. HB 1608 from Delegate Helmer is identical to my SB 1450, which is about standards of responsible conduct and civil liability for firearm industry. Okay. Motion and a second to report this identical bill. All in favor, please say aye.
Aye.
And we'll note 2 noes. Okay. Does that complete all the non-claims bills? Okay. So now, okay, Delegate Sullivan.
Do we have is Mr. Grimm? Great.
Oh, we need to,
The Senate of Virginia, Richmond, Virginia.
okay, we're back. We're considering Delegate Rip Sullivan's HB 1914. There is a substitute. Are you familiar with the substitute, Delegate Sullivan? Okay. Could council?
It's been described to me, Senator.
Okay.
I don't have a copy of it, but it's been described to me.
Okay. Could, do you want to do that, or do you want council to describe it?
Since I've just been handed it, maybe
Yeah.
council could describe it.
Yeah.
That'd be great.
Okay, council?
Mr. Chair, the substitute would leave existing law as it pertains to the execution of a waiver and release, so it would be the state and local release. That would remain. It would no longer require an agreement with the locality, and instead it provides that in the event that any compensation includes the additional compensation for intentional acts, the Commonwealth award has become effective and payable, and the locality employed the individual committing the intentional acts, then the person wrongfully incarcerated shall be compensated by such a locality with that matching sum. In addition, it provides I guess what we're calling state aid local intercepts, so that if the locality does not provide that compensation to the individual, the governor can withhold state funds to the locality.
Okay, Delegate Sullivan, do you want to add anything to that?
I don't, Mr. Chair, other than to thank council and members of the committee and probably others who had their hands on this for their creativity in trying to solve this problem. What my 1914 address, Mr. Chair, was what I thought was an unintended
Mr. Chairman, I
consequence.
know we had it explained, but did we adopt the?
Okay, so first we're going to vote on adopting the substitute. All in favor, say aye.
Aye.
Okay, back to you, Delegate Sullivan.
Thank you, Mr. Chair. What my 1914 was intended to address was what I think was an unintended consequence of something this body did now, what was in 2018, 7 years ago, having to do with the Norfolk 4, recognizing that in a case of intentional conduct that led to a wrongful conviction, enhanced compensation was proper. And in that case, since there had already been litigation and such with Norfolk, the solution in that particular case was to have the state double the base amount and then have the locality match it. The statute created, as I said unintentionally, sort of a veto power or a block, if you will, because it talked about unless and until the locality matches it, the state doesn't pay the claimant the enhanced award. So my idea was to try to fix that. This is a different way, an artful way, and as I said, I appreciate the creativity of council and the body for coming up with it. So that's what the bill does. It will result in specific cases, only in cases where there is intentional conduct that leads to a wrongful conviction, an enhanced award to these claimants that will equal, assuming it's in the general, this is all in the General Assembly's discretion, but assuming the General Assembly decides to do it, could equal, I guess is the word I should use, up to 4 times the base amount available under the statute.
Okay.
Mr. Chairman,
Senator McDougal.
I'd move to report. I think that appreciate everybody working on this to come up with a solution. And I think it makes a lot of sense that intentional acts are treated differently with a higher penalty or higher compensation back to somebody who's been wrongfully incarcerated.
Okay. So Senator McDougal moves and Senator Lucas seconds that HB 1914, that the substitute be reported, recommended for reporting to the full committee. All in favor say aye. Aye. Any opposed? Okay, so that bill is recommended. And now we have your claimant bills.
Shall we start with 1776, Mr. Chair?
Sure.
So, thank you, Mr. Chair, and members of the committee. 2 things. Before I begin, this relates to a gentleman named Marvin Grimm. 2 things I want to do was, one, thank the body, thank you, Mr. Chair, you, Madam Chair. I know I spoke to Senator Marsden about it. Thank Madam Clerk, IT staff, for making the arrangements for Mr. Grimm to appear virtually this morning, which I know is not the norm. The second thing I want to do is I didn't discover that was not the norm until this morning, and I sort of barked at staff a little bit about it, so I want to apologize to staff for that. This is a bill that I thought merited special treatment, and so I'm grateful to all for making the arrangements. Mr. Grimm is about to testify virtually. And since he's going to testify virtually, I'm going to take just a moment of time to create context, but you need to hear from him rather than me. This is one of those situations which we were just talking about with 1914. Not often, but too often, the Commonwealth wrongfully convicts an innocent person, and we have this process in place to try to right those wrongs. I've done a lot of these over my course of my career, and these stories are always awful. But there's something just a little bit more awful about these 2 gentlemen you're going to hear from, at least the bills I'm carrying, because this wasn't something that just happened to them. This was something that was done to them by people acting in our name, acting in the name of the Commonwealth. I've sent all of you, I think, a lot of materials about these cases, and you're going to hear from Mr. Grimm that these cases involved intentional conduct. You're going to hear the effect it had on him. Just to summarize, in both of these cases, law enforcement fabricated evidence, they suppressed evidence, they purposefully ignored and withheld exonerating evidence, and they coerced and knowingly offered false testimony. Background, some of you may remember this. Mr. Grimm's situation began in 1975 here in Richmond. The terrible death of a young 3-year-old child. The community was very anxious about it, and it became important to produce a defendant, and that defendant became Marvin Grimm. Mr. Grimm was 20 years old at the time, had a new son, blanking on how old, but very young, whom he's only met once since, I think, is the testimony. But he went in at age 25 and came out of prison at age 65. 45 years in prison, wrongfully convicted. And all the time known both in prison and outside of prison. Of course, his family had to carry this burden as a sexual predator of a child. So I view these bills not just as a legal obligation of the Commonwealth under our code, but as a moral obligation. And I want you to hear from Mr. Grimm so he can describe for you why we should do what I hope we're about to do. Is Mr. Grimm available?
Mr. Grimm, if you're there, we'd like to hear your testimony.
Can you hear me?
Yes, sir, and we can see you.
Thank you, sir. First, I'd like to thank the committee for their time to hear me. Obviously, there's no amount of time that would be enough to fully share how this impacted me and my family. But if I could have a few minutes, I would like to share some thoughts. My name is Marvin Grimm. I'm 69 years old. I will be 70 years old in April. I was wrongly convicted of murder and sexual assault of a 3-year-old boy, the most heinous of crimes. On December 16, 1975, the day I was originally picked up, I was 20 years old. I was a Navy veteran working to support my wife and 10-day-old son. Before that day, I'd never been arrested for anything. From that day on, I spent 45 years of my life in prison. I was not allowed to return home until I was released on parole in April 2020, a few days before my 65th birthday. I spent the next 4 years on restricted parole, sex offender registry, my electronic devices monitored at my own expense, could not attend church, was not allowed to travel more than 50 miles from my home. I also had a 9 p.m. to 6 a.m. curfew. At the age of 69, 49 years after I was first arrested, I received my freedom when the Virginia Court of Appeals exonerated me last July 2024. Almost 50 years ago, the Richmond police picked me up at my job as I was finishing a 9-hour shift and took me to the police station for questioning. I lived across the hall from the family whose child had gone missing. At the station, the police spent 10 hours trying to convince me to confess. I could not eat, drink, or eat, or call my wife to let her know I was okay. They were loudly insistent. They threatened me with the death penalty. I was terrified, having witnessed 2 shipboard inmates die due to an engine room explosion and fire. I was terrified at the thought of dying. I eventually became so tired I could barely stay awake. Sometime after midnight, they took me to where the body of the victim was found. When we got back to the police station, it was after 2 a.m. At that point, I was awake for almost 24 hours. When we returned to the police station, they finally read me my rights and turned on the tape recorder. I was falling asleep, but I repeated everything they told me to say, and I was just trying to get away from them and go home. Instead, I was arrested. The next day, I could not even remember what I said on tape. At this time, I started recanting my confession. There was a motion to the trial court for a voluntariness hearing on the confession. It was never argued. The day of the hearing, the jail employees burnt me my suit, told me to get ready. I waited till about noon, and then they came back and told me the hearing was postponed and took my suit. Instead, my attorneys told me that the Commonwealth would offer a plea deal. They said that the Commonwealth would not seek the death penalty if I pled guilty. I was afraid of dying for something I did not do. Nobody told me that the death penalty did not apply to the crime I was accused of. Also, I was told that the blood testing results were inconclusive, even though, as I later learned, they proved I did not commit the crime. Furthermore, I was told not to say anything during my guilty plea hearing, or the court would reject my plea deal, and that I would be convicted at trial and I would receive the death penalty. So I took the deal. When I was sent to the state penitentiary, I was ordered into protective custody or segregation because of the death threats against my life. I spent the first 6 years in solitary confinement. After my conviction, my wife left me and my newborn son and went back to her home with her parents in another state. I never saw him again. He grew up thinking I was a heinous monster. During my 45 years in prison, I never stopped trying to get review and allow me to show my innocence. The writs were always denied on some procedural error or technicalities. Furthermore, I had to fight to get the DNA testing, and I was denied parole over 25 times. Nobody would listen. Then in 2007, God opened the door for me, and the Innocence Project took my case. And this now allows me to stand before you a free man, and my nightmare is over. I was not the only one who suffered from the unlawful incarceration. Because of the extensive news media coverage, my 3 younger sisters also suffered the trauma. People turned on them. Richmond turned on them. One sister lost her life to drug addiction, and another had to seek therapy. I'm sorry. I lost approximately 96% of my adult life, and I missed out on all things most people take for granted. Weddings, birthdays, holidays, trips with family. My mother stood beside me and made noise trying to get the courts and officials to see the truth. During it all, my mother and sisters never stopped believing in me. They visited me in prison. Mom wrote letters to officials. She also went to the parole board to argue my case approximately 20 times. But then when my mom passed in 2015, I was not even allowed to attend her funeral. After my mother's death, my two sisters, Lisa and Sharon, took her place by keeping up the prison visits. They are the ones who greeted me with open arms when I came home on parole. They continue to support me today, along with my nieces and nephews. And I would like to thank the committee for considering my bill, and God bless you all.
Thank you for your testimony, Mr. Graham. I don't know if there are adequate words that I can state to express our concern and regret, deep regret, what happened to you, and it shouldn't happen to other people. So I appreciate your being here, not just for yourself, but to shine a light on some reprehensible and horrible practices and what happened to you. Thank you for persisting and for being here today, as we can try and recognize the injustice that happened. Judge Sullivan, is there anything you want to say to conclude?
No, thank you, Mr. Chair, other than that you are right. There's no amount of money that can right this wrong, but this is the best way we can do to try. Ask yourself how much money you would take to spend 45 years in prison, and the answer is there's no amount of money. So this is how we do our best to try to right these wrongs, and I hope it'll be the will of the committee to pass this bill.
Can I ask counsel, there was no substitute for this bill, was there? Okay. So
there was an amendment in the House, but
it's
before there's nothing.
incorporated in what we have.
Yes.
Okay. So is there a motion to recommend reporting of HB 1776?
Mr. Chairman,
Yes.
I worked with Delegate Sullivan on these kinds of measures for years, and it doesn't seem to ever get any better, does it?
It does not.
And so I would like to recommend that this bill be reported.
Senator Lucas moves, and I second that report HB 1776. All in favor, say aye. Aye. Any opposed? Okay. Thank you. And thank you, Mr. Grimm, for being here. And then you had another.
I have 1780.
Yes.
Thank you, Mr. Chair. Once again, I will take just a moment of the committee's time to provide a little context, but Mr. Merritt is here. That 1780 involves a gentleman named Gilbert Merritt, who spent 20 years wrongfully imprisoned in Norfolk. Again, this case was one that falls into the category we've been talking about that resulted from intentional conduct. This one, I'll just read you. This involves a gentleman I know whose name you've all heard before, Detective Robert Glenn Ford. And the court found that Ford's conduct was aimed at engineering a specific outcome in which Merritt would be wrongfully convicted and Ford would take credit for solving a homicide. Mr. Merritt then spent 20 years in prison, and he's here this morning to tell his story to the committee. So I'll ask Mr. Merritt to come on up.
Ladies and gentlemen, I'd like to thank you for allowing me to come here today. I came here like a week ago. It's like really emotional. Every time you talk about it, it's like I done been through a lot of therapy. It's nothing's working, because like every time I speak about it, it hurts me. You know, you gotta. I was just looking at him, and he said 45 years. It's like, when do we stop? You know, like you got individuals in power with no care, no nothing, like just to do this to somebody. You know, I had twins. I come home, I'm living with them. They was on the floor fighting for cereal when I left. Now I gotta live with them until I get myself situated. You know, and I keep thinking like I wasn't a real bad person. I wasn't. I probably done some bad. I was a kid. I still rode bikes. I didn't even have a car. Didn't even have a car. I did everything, cut grass, everything. You understand it? Just one day I decided to go hang with some friends and never came home. Never came home. I don't understand that. I always used to think like somebody was gonna come get me. Nobody came and got me. I'm sorry. My main thing is to ask why. Like, what was the reason? You know what I'm saying? Why happened? That's what I want to know. Like, why me? You know what I'm saying? Like, I ain't do nothing. Nothing. Oh my God. I be thinking like I could get through this. I just was telling her, I said I could do this. It's hard. It is real hard.
Mr. Chairman,
Senator Lucas.
could I just recommend that the bill be reported?
Okay, so there's a motion and a second to report this Bill 1780. Mr. Merritt, I just want to say before we vote that we appreciate your being here, and I can't express enough regret at what's happened to you, and hope that we can at least recognize what was done was more than wrong and more than an injustice, but something we don't want to see ever repeated again. And I appreciate your coming forward so that people can know that this has happened, and hopefully we can avoid repeating it. Thank you, sir.
Thank you.
Okay, so there's a motion and a second to report HB 1780. All in favor, please say aye.
Aye.
Okay, any opposed? Okay, that bill is recommended for reporting. Thank you, sir. Thank you, Delegate Sullivan.
Thank you, Mr. Chair and members of the committee.
Okay, now we have Delegate Siebold.
Thank you, Mr. Chair. Before you, I have 2691, Mr. Chair.
Yes.
Mr. Chair, before I start, I want to express my gratitude to Delegate Sullivan, who shared this bill with me, and gratitude to Senator Lucas, who I know has been working on wrongful incarceration bills for many years. And in my 3 years that I've been in the General Assembly, this by far is the most meaningful piece of legislation I've carried. Unfortunately, Mr. Duffy could not be here today, but I'm here to be his voice, and I'll try to provide that justice for his injustice. Mr. Kashawn Duffy was convicted in 2019 in the city of Hampton for 2 counts of the felony offense of forcible sodomy with a minor. He was sentenced to life without parole on March 22nd, 2019. He had served 5 years when the accuser recanted his testimony in June of 2020. Mr. Duffy was then ruled wrongfully convicted, but this was after serving 6 years in several different facilities in Virginia, and where he lost his freedom and countless life experiences and opportunities and relationship with his family members. So I'm here today to represent him, and hopefully we can give him justice where that has been taken away from him for so long. So thank you, Mr. Chair, for this opportunity.
Thank you for bringing this to our attention and taking up this cause. So we have HB 2691. Are there any questions before we take motions? Okay. Is there a motion to report?
Yes, Mr. Chairman, having worked on these issues for years, I know that by the time we get to this point, we've gone through an arduous, thorough process of making sure that what we're doing is the right thing. So I recommend that this bill be reported.
Second. There's a motion and second that HB 2691 be reported. All in favor, please say aye.
Aye.
Aye. Any opposed? That bill is recommended for reporting. Thank you.
Thank you, Mr. Chair, members of the committee.
Thank you for being here. Does that complete our docket? Oh, we have another claim. Okay. Thank you. Senator Marston.
I'm sorry, do we have a motion?
Well, you had a comment on something?
I did. I just spoke to Senator Lucas, and it's ironic, I think, that sometimes the amount of effort we have to put into making these things right is so much greater than the wrong and the effort we put in to do the wrong in the first place.
Thank you for the observation. Yes. What was the last bill number?
1586.
1586. Okay. Yeah, why don't you describe it? It was 1596, you said, or 86? 86.
1586. Mr. Chairman, 1586 by Delegate Ware. This is a claim for Mr. Michael Haas. If we just adopted a formula that would essentially clarify that the time on the sex offender registry, the amounts are post-release, so he would be eligible for about $140,000. The other thing this does is it basically has a look back where we're amending the wrongful incarceration statute to say it's for awards after 2023. This essentially only applies to 2 people, and this allows them to get time for their amounts for their time served on the sex offender registry, since that change was adopted last year in the General Assembly. So it's just for these 2 folks that almost made the window but didn't quite, and we did it for 1 last year, and this is the remainder.
Senator Hashmi.
Thank you, Mr. Chair. Just to speak briefly to this, Mr. Michael Haas was a constituent of mine in my previous district, and I had carried the legislation that was to compensate him for wrongful incarceration. His story, too, is a powerful one of injustice, and I hope that we might be able to support this.
So thank you, Senator Hashmi. So it's been moved and seconded that we recommend for reporting HB 1586. All in favor, say aye. Aye. Any opposed? Okay, that bill's recommended for reporting. And I think, is Delegate Austin, did you have anything before us today? Oh, you're waiting for the full, okay. Okay, and the full committee is going to meet on the 3rd floor at 9 a.m., I guess it is? Or?
5 minutes.
Oh, it's 5 of 9, great. Wrapped up just in time. Thank you.
The Senate of Virginia, Richmond, Virginia. Senate Committee Room, 1300. Did you know live Senate video is now available at youtube.com/@Senate of Virginia. Senate Committee Room, 1300.